Check out what the satisfied Dan Gemus real estate team clients are saying about working with the Dan Gemus team. Visit dangemus.com.
I got to thank you for being a voice of reason in a sea of insanity.
Now back to the Dan Gemus Real Estate Show on AM 800.
Okay, I'm with Heather Marintet in studio today, and we're having lots of fun. Our fun question today, what home-related chore do you dislike the most, and which do you not mind so much? You can keep sending your responses in. We'll share some more with you in the next segment here on the Dan Gemus Real Estate Show. But in the meantime, we have our good friend Christian Janisse from SimplyClose, a real estate lawyer. Hey, Christian, how are you? Hello, Christian. There you are.
Can you hear me?
Yes, I hear you. How are you?
Hey, I'm great. How are you? How are both of you?
Fantastic. Very good. Thank you so much. So, and very interesting topic today. So basically, what happens if a home that you just purchased but have not closed on burns down between the purchase sale agreement is signed and between closing?
Yeah, so I thought that was a pretty interesting case that I sent your way. It's actually from this March, so it's very recent. It just happened like a week ago. It was just released. Okay. And essentially, as you know, when you sign the agreement of purchase and sale, there's often a period of time between when you sign and when you actually take possession.
Sure.
So in this case, buyer signed in May, scheduled to close in August, and just a few weeks after signing the agreement of purchase and sale, the house burns down to the ground. The standard agreement that is issued by the Ontario Real Estate Council says that if that happens, you have two options. You either have to close and you accept the insurance money from the seller,
yep,
or you can back out and you'll get your deposit back and there's no penalties and whatnot. But those are the only two options that you have. You don't get to try and optimize it, and this has always been the case, but this is what happened in this particular instance. You don't get to try and optimize the insurance. You don't get to know how much the insurance is. You don't have to, you don't get to dictate a minimum guarantee or anything, which is what happened here. So the buyer in this case chose to proceed with the purchase. Again, it burned down in May as well. So that, I think that played a factor here. It's not like it burned down like a week before closing.
Sure.
So there was plenty of time to discuss the insurance. They actually knew how much they were going to get for the insurance in this case. Or they had a guarantee, like a certainty that insurance was going to cover it. They just didn't know the amount.
Sure.
And on the closing date, they sent the money to the other lawyer and they said, we're not going to register the change of ownership unless you guarantee the amount that's going to be provided by the insurance company. And the seller's lawyer said, you've already extended 2 to 3 times to try and go back and forth and inform yourself on this. So the seller, I think, was being reasonable because they did give the buyer an opportunity to, make a decision. It's not like it burned down the day before closing and the seller was unreasonable and said, yeah, you know what, we're out. Although I don't know how that would have actually affected the outcome.
So Christian, I want to be clear. So the house burns down in May. The closing is in August. Are you saying that the buyers didn't know how much the insurance company was going to pay out before making a decision as to whether to proceed or not?
Yeah, they didn't know how the exact amount.
So how do you know if what you get is going to be enough to rebuild the house?
That's the issue. And that was the issue that the buyers had. But the agreement of purchase and sale says you either accept the insurance proceeds or you can back out. So in this case, the buyer should have backed out. And went and found another house. They didn't, and then on the day of closing, they gave the money, and they said, well, we're not actually going to register and actually close this unless you guarantee a minimum amount that the insurance company is going to provide. And at that time, they had already extended the closing date 2 or 3 times. So the seller's lawyer said, you know what, we're going to accept that as a breach. They gave the money back and actually held back the $25,000 deposit, which is kind of crazy, and said, you forfeited the deposit. So they gave back all the money, less the deposit, and then the buyer brought an application to the court to say that they should have to proceed with the sale of the house, and the judge disagreed and said, nope, the options were you either accept the insurance proceeds as is and close, or you can back out. You chose to go through with it, and then you decided to unilaterally, on your own, add an additional condition that was not a part of the agreement of purchase and sale. Therefore, you lose the deposit and you lose the house.
Mm-hmm.
And they probably had to pay the legal fees for their lawyer, obviously, but also the seller's lawyer, because that is what the agreement says. And just to be clear for the audience, this isn't just if the house burns entirely to the ground. It's any major damage to the house. So if a basement floods, you can back out if it's, substantial damage, such that it like changes the way that the house was presented when you put the offer in, or you can accept the insurance, but you can't guarantee what it's going to be.
So although in my years in real estate, I have never had a house burn down in that time period. I've had houses burned down, but it was not in that time period.
Right.
I have had clients that had a basement flood, a major flood, between the sale and the closing.
Oh, okay.
And in my case, the buyers were actually a little happy because they were able to pick all their finishes.
Brand new.
And the insurance company took care of the renovation and fixed everything. And the buyers were able to select all their colors and their flooring, etc. So they were actually not disappointed that it had happened.
Yeah. And in this case, the insurance company would have rebuilt the house and they could have proceeded. They just didn't know if it was going to cover everything that they wanted. If there would have been a dispute over, the exact amount that was the replacement value of the house, because I think it was older in this case.
Yeah.
But the main thing is that obviously I totally understand why the buyer wants certainty, but the way the judge viewed it was that the certainty was that you could have backed out without any repercussions, which is obviously not ideal for a buyer. But in this case, I personally think what really played a role was that it didn't burn down a week before closing, where these people were scrambling, trying to make a decision on the fly. It burned down a couple of months, like they had really thought about it. And then at the very last minute, like to even send the money, they sent the money to the other lawyer and everything. And then at it's almost like they tried to blackmail them to say like, well, you've got everything except for the fact that we haven't registered the change of ownership. And the only way we're going to do that is if you guarantee this. It did seem like the buyers were kind of playing games in that sense.
Jeez.
Yeah.
Man, oh man.
Yeah.
To me, like the perfect scenario there is take away what the agreement of purchase and sale says. But in my mind, the house burns down. As a buyer, you would think, okay, you know what? I get a brand new house.
Yeah,
really,
something
it's the
brand
worst
new.
case scenario. I get a brand new house to the same home, just brand new. But I guess, like you said, right, it's not necessarily the case. You don't know what insurance coverage is like, and they could have been maxed out, and whatever.
Yeah, I
So
guess
it's
you
not
don't know their
necessarily
scenario
replacement
with their
costs, right?
insurance.
Yeah, more question for Chris Gibb as well. But having just gone through family that had a full home, burned down a couple of years ago. And having to deal with the insurance company, it was interesting, right? So
I'm sure.
And there was a maximum to their policy, so it could get sticky for sure.
And everybody has a different policy.
Yes.
But as the buyer, you get to assess the policy. Like, I don't think it's unreasonable to say, like, well, in order for us to agree that we're going to accept the insurance to close, we want to know what the policy is, because some people have like a fixed value and some people have like a guaranteed replacement cost.
Like, to me, in that time, the buyers could have, or the sellers, whatever, could have dealt with a builder, which would have quoted the rebuild, and somebody would have known if the insurance would have covered the cost of the rebuild in those few months.
And that's what I think is different about this case, because I think what happened was I think the buyers knew what the agreement of purchase and sale said. They knew what their obligations were. But I think what they did is they tried to pull a fast one because there was some uncertainty. So on the day of closing, they send the money, they exchange the documents. Now, if the sellers are buying another house and that deal doesn't close, that's on them, right?
Yes.
I don't know what the seller's situation was. So I think the buyer was trying to say, well, if you want to use this money, we're only going to register if you guarantee this. Like, they tried to pull a stunt at the last minute and say, this is what we have to do. And it wasn't like we haven't exchanged documents or exchanged funds. We've already done everything except for register. So I think they were trying to like put a gun to their head at the last minute kind of thing.
Gotcha. Wow. Okay. Well, Christian, before we let you go, our fun question today: what home-related chore do you dislike the most, and which do you enjoy a little bit more than dislike? What would you say?
Which one do I like? That's the hard one. The one
Dislike
I
least.
the most. I dislike washing the bathrooms.
Yes, of course.
The most. If I dislike the least, I'd probably like taking out the garbage.
Yeah. Nice and easy and quick.
Yeah, quick.
I gotcha. All right. Listen, if someone has questions for you, what's the best way to reach out to the Simply Close team?
They can call us at 519-997-3775 or email us at hello@simplyclose.ca. Thanks, guys.
Fantastic. Thanks, Christian. See ya. That's
Have a good day.
Christian. You too. It's Christian Janisse with Simply Close law firm. So, wow, interesting stuff there. But
yeah.
It's never fun to have to deal with these kinds of things.
No, the
playing those
unexpected
in sorts.
type of scenarios. They don't happen often, but I mean, they can.
It happens. It happens for sure. Okay, Heather, we're going to take a break. We're going to come back and get back to our fun question. And you can share your answers with us, 519-792-2559. In the meantime, we're going to give away a gift card for the Richmond Popcorn Company. The Bunny Bait popcorn is officially on the shelves.
That is good.
Yeah. One of the
Yep.
top-selling holiday flavors of all time over at Richmond Popcorn in downtown Amherstburg, with a location coming to Tecumseh Mall in this spring.
That's so exciting.
It's coming. It's coming. So in the meantime, you can go to the Amherstburg store and go check out all their flavors, including the Bunny Bait. You want to be caller number, Heather?
3.
Caller number 3. Oh, nice and quick, Heather. Making it
Nice
easy.
and easy.
Making it easier for the producers. 519-792-2559. Caller number 3 gets the gift card for the Richmond Popcorn Company. Lots more to come right here on the Dan Gemus Real Estate Show.